Hi, everyone. I'm Matt Rizzolo, an IP litigation partner in Ropes and Gray's DC office, and I'm here with my colleague Scott McCune, chair of our firm's Patent Trial and Appeal Board practice and founder and author of the award-winning patentsPostgrant.com blog, and who was recently profiled by Intellectual Asset Management as one of its global IP leaders. So after some small technical difficulties, we'll get started here. And thanks for joining us on our first Transition Tuesday. It's the new conversation series where Ropes and Gray attorneys will explore some of the regulatory and legislative changes that may be emanating out of Washington, D.C. After the outcome of the 2020 election and as we head toward the new year. Today's session will focus on what the Biden administration may hold for intellectual property rights in the United States. So for those of you watching on video, here's a high-level agenda of what we'll be discussing today. But first, a couple of housekeeping matters. Please feel free to utilize the Q&A function at the bottom of the screen to submit any questions at any time. We'll try to address them as we go or at the conclusion of the program. And with that, I'll turn the conversation over to Scott to start us off with some of the changes we can expect to see at the U.S. Patent and Trademark Office.
Thanks, Matt, and apologies on the video quality. Not that anybody really wants to see my face anyway, but so yeah, we're coming to the end of the Iancu administration. It's customary, and that sounds loose, but it's almost a requirement of a director to, they're expected to submit their resignation. That will happen from Director Iancu, just like it did for Director Kappos, who mid sort of Obama administrations also was switched out, even though the same party held office. So Director Iancu will be moving on here in the short term. And the question becomes, well, what does that mean for the patent office? And I think in the short term, it doesn't mean a lot. We'll have an interim director probably until at least late spring, early summer, until the expected Biden administration comes in and gets down to that level of appointment. So very likely someone like a Drew Hirschfeld, director of patents, will take over. And certainly the job of the interim director is to just keep the trains on schedule and to keep things going until the next leadership change. And so that's what we're looking at least for the first half of 2021, which is interesting given there are a number of developments sort of in the works right now, developments being rulemaking efforts, especially for the PTAB. There is a request for comment pending on the PTAB's discretion of yielding, so to speak, to parallel litigation that may conclude before the PTAB could do its work in an IPR, for example. There's a request for comment out with comments from the public due on December 3rd, I believe, which was an extended date, was supposed to, I believe, end maybe this week or last week. But the effort there is to solicit public input on the discretionary practices of the PTAB. This has been in the news a fair amount lately, depending upon which side of the V you're on. If you're a patent owner, you may be a fan of these discretionary practices. If you're a petitioner, probably not. So this rulemaking effort is looking to go through the traditional Administrative Procedure Act notice and comment rulemaking to essentially codify what the board is doing right now in terms of the Apple versus Fintiv case, which has now become known as the Fintiv factors. So there is a effort that is starting now that will certainly span over the transitional leadership. So we can expect to see draft rules probably very quickly after this December 3rd date, maybe early in January, proposing what I believe are rules that are already written. The Patent Office tried to get these rules through back in the fall, and there was a lot of pushback from a number of stakeholders. So it's been controversial, as I mentioned, and the effort is at least to get this rulemaking effort started so that it can then on momentum, sort of just finish up in time before the next leadership comes in. And I believe that's the current director, Director Iancu's wish, is to get this done because in addition to the controversy I mentioned on these controls for discretion, there's also litigation pending. A number of large tech companies have sued the agency, stating that number one, these practices are in direct contradiction of the America Invents Act and are therefore unlawful. And then secondarily, which is probably the aspect of the lawsuit that the agency is most concerned with, are just run afoul of the APA because they are essentially controls on the public that were not promulgated based upon traditional notice and comment rulemaking. So we've seen a number of cases out of the federal circuit essentially knocking the agency for trying to, in effect, pass rules through PTAB adjudication, and that was in Aqua Products and the Windy City. So the writing's on the wall out there in terms of if this APA dispute on these discretionary practices made it up to the federal circuit. So the agency is trying to essentially beat that case to the punch, perhaps get these rules going so that maybe they might even be able to stay that lawsuit. So that's where we are on the patent office side, and my expectations of what the the election will have impacted on what's going on at the PTAB in particular.
All right, thanks for that. We've seen in the news a lot of Biden selections, pre-nominations, if you will, for various cabinet positions. Does this signal anything to you about the type of person that President-elect Biden might choose to lead the PTO? We've seen in some of the national security and intelligence positions that they've been fairly traditional, and for a lot of people, I think, who don't practice in that area or aren't familiar with that area, they may have never even heard of the person, which is somewhat different than some other presidents in the past have taken. These are less flashy nominations, if you will. Do you think that's where we're headed with the PTO?
Well, I mean, I think the position's gotten a bit more politicized over the years, especially now that there's essentially a tug of war, so to speak, between big tech and biopharma. And I think Biden is on both sides of this fence in that Silicon Valley certainly supported his candidacy, Democratic candidates overall. And at the same time, you've got President-elect Biden himself that comes from Delaware and is very close to a Senator Coons that is also very close to biopharma. So, it's interesting in that he's got two constituencies to serve here. And again, I would not underestimate the influence of a Chris Coons on Biden. And we'll get into a little bit later, Senator Coons' involvement in the Stronger Patents Act, for example. And together with Senator Tillis, I've taken a fair amount of PAC money from some of the biopharma folks. So I think it's going to be interesting to see how that plays out. And we may end up almost where we are with politics in general, getting someone that's more of a moderate and in the middle, as opposed to all the way pro-patent on biopharma side, or, not to call big tech anti-patent, but certainly given their size and the value of patents to big tech, I think are quite different than they are to pharmaceutical companies. So my expectation is someone that's not controversial with respect to either one of those constituencies. So it may be someone, who's more moderate and not necessarily on either side of those fences, so to speak.
So that's a good transition, I think, to some of the potential IP-related legislative proposals that may come out with the new Congress. And maybe it's led by the new administration, or maybe it's led by individual members of Congress. But you mentioned the Stronger Patents Act, and this is something that Senator Coons has sponsored on a number of occasions over the last several years. The Stronger Patents Act. We haven't yet seen the strongest. Maybe we'll see that coming in the next year or so. But these are all bills that have been viewed as being much more pro patent owner, strengthening the enforcement or the ability to enforce patent rights in the district courts while simultaneously weakening the PTAB. Given the number of different legislative priorities that are out there right now, do you see significant chances of a broad, strongest patents act, if you will, coming out, or do you think it's going to be more targeted?
I think any legislation that we would see is probably, certainly not something that we'll see in 2021, absent some Arthrex fix, which we can get into. But in terms of any real effort, frankly, I think that there's some burnout there from the 101 efforts of last year. There was a really strong effort there to sort of put that to bed and come up with some kind of legislation that would fix, or at least, I shouldn't say fix, but clarify, because no one seems to be able to predict 101 for any given fact pattern. And there was a lot of effort, a lot of witnesses that came up to the Hill. That whole effort just completely fell apart. And at least some ABA meetings last fall, there was sort of palpable disgust from some of the legislative folks that were involved in that. So I don't expect to see any real effort, at least in the first year, to get this thing going. Keep in mind, our last major IP bill, the AIA, was sold as a Jobs Act, or was, to create jobs on Main Street USA. And so, absent that kind of appeal in an election year, it's really hard to get Congress interested in these topics. So when you talk about the Stronger Patents Act, and as you alluded to, it's been introduced, I think, every year since 2014 and never gets out of committee. And the reason for that is it's a fairly lopsided bill in terms of being very, very sort of not only pro-patent, but I think very driven by the biopharma folks, where tech is on the other side of it. At least this is the way they perceive it as well. We don't like any of this stuff. So, that bill in particular, I don't think that's any closer to the finish line than unwritten bills, frankly. So I think, given everything that's on the plate of Congress with the pandemic and just political developments, we'll just say, to be diplomatic, it would seem like anything other than a very targeted bill, that may be added into, another bill that's on its way to passage would be pretty unlikely.
One issue that I wonder may come up that could be a hook for some sort of patent legislation would be Section 101 and the diagnostics realm, given that diagnostics patents have really suffered under Section 101, and given the very, very high emphasis on testing in the midst of the pandemic. You wonder if there may be some biopharma momentum behind that type of proposal.
Yeah, that's a possibility, but I just think 101 is a little bit radioactive right now. A lot of folks feeling a little bit burned, and that they put a lot of time and energy into it, and then you just had the Hatfields and the McCoys on each side, and no one could kind of agree on anything. And to the extent there were sort of a targeted bill on diagnostics, a lot of that may impact what happens with Senator Coons, right? Does he take a position in the cabinet? His position, I think, in driving a lot of this is critical if he were to try to get some targeted legislation through. So we'll have to see where he ends up, because if he were to migrate, to a cabinet position, maybe there's a little bit of knowledge base and momentum lost there on, sort of any change on that side of the patent law fence.
You mentioned a potential Arthrex related fix concerning the constitutionality of the APJs at the PTAB. One other issue I think could be a potential area for a relatively targeted piece of legislation would be the patent venue statute and Hatch-Waxman litigation. There was a Federal Circuit case that came out a few weeks ago where the Federal Circuit pretty significantly curtailed where Hatch-Waxman proceedings could be brought under the patent venue statute, saying that the active infringement that's relevant for purposes of the patent venue statute is the submission of the ANDA to the FDA itself, not where the generic would be marketing or selling the drug in the future. So this is something that we could also see moving on. But on that note, move on to talk a bit about the Biden administration and pharmaceutical patents. Obviously, in the midst of a pandemic, this is an area that is getting a lot of attention, and it gets a lot of attention even when we're not in the middle of a pandemic. Biden has been much more muted on the issue of drug pricing and IP than many of the other Democratic presidential candidates, including Vice President-elect Harris, who Vice President-elect Harris and some of the others, such as Elizabeth Warren, Bernie Sanders, have called for the government to either break or seize patents in order to try to lower drug prices. But President-elect Biden has been vocal in the past about his opposition to compulsory licensing regimes that other countries have regarding pharmaceutical patents. So I think, this is not something that we're likely to see as much movement on that we would otherwise have had one of the other Democratic presidential candidates won, but it's still something worth keeping an eye on. The subject of drug pricing and IP, I don't think is going to go away anytime soon. And we'll be hearing in some future Transition Tuesdays episodes from some of our life sciences colleagues about this issue in more depth.
I think it's an interesting tug of war, similar to the big tech sort of biopharma that I alluded to earlier, which is, on the one hand, Biden and Senator Coons seem to be somewhat friendly to biopharma, but at the same time, he's got this tug of war with the progressive end of his party, and this may be one of those issues that is less controversial, I guess, to moderates than others. And so, I wonder how much of that end of the political spectrum will play into his consideration on some of these topics.
So on some of the other IP related topics that we have listed here, or IP adjacent, if you will, like trade, for instance, and trade secrets, the internet, let's go through some sort of quick hits. President-elect Biden has a plan to empower workers, and he's called for eliminating non-compete clauses, except when absolutely necessary to protect a narrowly defined category of trade secrets. And he's also called for eliminating all so-called no-poach agreements. Given the uptick in trade secret litigations over the last few years, especially since the enactment of the Defend Trade Secrets Act back in 2016, this is something that companies should really be keeping an eye on to see whether this expands beyond what's been put out there so far. On trade, I think the shift that we'll see is likely to be one that's more of process rather than in tone. President-elect Biden has shown an inclination for more multilateral trade and treaty negotiations as opposed to President Trump's bilateral approach, that sort of one-off approach. But at the same time, we've heard the rhetoric from President-elect Biden, especially towards China, criticizing cyber attacks, cyber espionage, et cetera, as well as the protection of IP rights and enforcement against counterfeit goods. So I think there's going to be probably not a significant shift on the trade front. And then touching on the internet real quickly, this wasn't really a signature issue for President-elect Biden, but he has called for a revocation of Section 230 of the Communications Decency Act. For the uninitiated, this is the statute that, among other things, can insulate social media companies from liability for content posted by its users. This is commonly used to protect against claims of things like defamation, but it can also be used to protect against state law IP-related claims, such as right of publicity claims. So that's also something to keep an eye out for from the Biden administration. Last but not least, we have a couple of IP related cases at the Supreme Court that could be particularly interesting for the internet and software companies, as well as for anyone who uses the PTAB. So first, start with the Google Oracle Supreme Court case, which addresses the copyrightability of software interfaces and whether, even if there is infringement of the copyright in any software interface, to the extent it's protected, that could be fair use. This dispute goes back about a decade, and we should be getting a ruling from the Supreme Court in the spring, maybe even in the winter, we'll see. So that is something to keep an eye out for. And then obviously Arthrex, you'd like to touch on that real quick before we wrap up.
Yeah, Arthrex has been an interesting dispute, I think, academically. There are a lot of folks, I should say, fervent critics of the PTAB that are hoping that, like some of the other challenges that made it up to the Supreme Court previously, that this somehow knocks out the whole system. I don't expect that to happen. And even if it did, it's really just one line of legislation that would fix the issue. And that would be just giving the director plenary review of any final written decision that came out of the PTAB. So, it's an interesting constitutional issue in terms of further delineating what is an inferior officer compared to a superior officer under the Constitution, and would therefore need consent and confirmation of the Senate. That's essentially the dispute, that these PTAB judges are superior officers, and yet they didn't go through the proper constitutional process. Practically speaking, I think as a practitioner, the real outcome of this is more what is it going to, or how is it going to impact the PTAB? In other words, how many cases would potentially go back for a different panel for, a second decision? Aside from that, again, I think it's more academic. I don't expect it to have a lasting impact on the system, whether the court decides that there are aspects of the statute that are severable, or whether the Federal Circuit solution actually makes sense and is a fine way to solve the potential issue. We'll have to see what the ultimate decision is. But again, even if they were to somehow decide that the PTAB itself is unconstitutional because of this issue, that's where I would expect targeted legislation, a line added to a bill that's about to be signed into law, just giving the director that plenary review. And there were at least some hearings back, I think it was last spring, maybe it was a little longer ago, but where everyone was pretty much in agreement that would do the trick. And I think Congress would be poised to provide that fix relatively quickly if that were the outcome. So we'll just have to wait and see how much additional work is needed, and where that additional work goes to. Is it the legislature, or is it just the PTAB sort of redeciding decisions with different panels?
Okay, so we should get a ruling at Arthrex by June, and then we'll see where that goes.
Yeah.
So thanks, Scott, for joining me, and thank you all for joining us today. We hope you enjoyed this program and that it was informative, and look forward to connecting with you all again soon. Tune in next week to hear members from our FDA regulatory and healthcare teams on the potential impacts of the 2020 election on the life sciences industry. Topics of discussion will include, as I mentioned, drug pricing reforms, laboratory developed tests, medical device priorities, potential shifts in FDA enforcement, and a path to market for all important COVID-19 vaccines and therapeutics. Have a great day.
Thank you.